Thank you, David. I'm sure that there'll be some discussion on that decision at the end of the Union Power. If I buy a car or if I buy a house, I'm very careful to have a proper inspection of what I'm buying. If I spend 10 or 20 times more in buying a ship, I probably have a 25-minute inspection with everything hidden or closed down by the owner, and I go ahead and purchase the ship, not really knowing its true condition. Then when I take delivery, I try and persuade an arbitration tribunal that the vessel was not in the same condition as when I inspected her, but I have no evidence of what condition she was really in when I inspected her. So it's a rather strange situation, a very insecure position that a buyer of second-hand ships has, and it's good to see the question addressed by the courts. We can discuss whether they addressed it in the right way afterwards. Let's move on, though, now to Jamie Wallace's talk. Jamie is a partner at Bentley's Stokes and Lowless, well known in this market, and Jamie has been down to Naples many times and has a large client base here. He's going to be talking about charter party issues and again some very important new decisions that have been made in London.
Thank you, Clive. Good evening. Thank you, Francesco, as well, for organising the conference today in these magnificent surroundings. I am extremely conscious that this is the penultimate talk of a very long day, also known as the graveyard shift, so I really will be as quick as I can. By way of an overview, I'm going to comment and highlight recent developments concerning non-payment of charter party hire and owners' rights regarding withdrawal and claims against charterers. I'm also going to consider whether two recent decisions in the courts in England have strengthened owners' hand in the face of non-payment of hire. Those two cases are the COS and the Astra. Now, you'll be relieved to hear that there isn't time to go into the detail of either case. They are freely available online. You don't have to have a subscription. You can obtain them from the court's website. There's also plenty of comment on the same on most lawyers' websites, including Bentley's, if I'll fly the flag for our firm. Both concern the withdrawal of time-chartered vessels following charterers' failure to pay hire, and, on the face of it, both appear to strengthen owners' hand. Before looking at the cases, I'll just briefly review what owners' options are if charterers fail to pay hire. In short, owners can choose to withdraw the vessel after the expiry of any grace period, if that's relevant, and owners can claim earned hire and any other sums due at the time of withdrawal. The latest decisions don't change those principles. What they have changed, however, is the approach to owners' right to claim damages for loss of future earnings for the balance of the charter period. So to claim damages, following any withdrawal, owners must demonstrate that charterers were in repudiatory breach of the charter. Again, this general principle hasn't changed. So owners, again, are still required to prove that, for example, charterers have shown an intention not to perform the contract, or essentially looked at another way, that the breach will deprive owners of a substantial part of the benefit of the charter party, a substantial part of hire, for example. Previously, the thresholds required to show that charterers did not intend to perform their contractual obligations was pretty high, and one missed hire payment was generally thought not to be enough, particularly if there was a genuine dispute between the parties over hire due and or the failure to pay arose from a mistake or oversight. As such, one missed hire payment after service of any anti-technicality notice, etc., might allow owners or would allow owners to withdraw the vessel, but without more, owners would struggle to claim those crucial damages for loss of future earnings for the balance of the charter period. The result was often, has been, that on a falling market, when owners are most keen to protect their hard negotiated charter party hire, withdrawal without a repudiatory breach rarely assisted owners, as owners can't claim or lob a damages claim at the charterers. Worse, owners have often shied away from withdrawing a laden vessel because of the potential risks, costs and delays involved in working out what to do with the cargo left on board the vessel. In particular, the question of whether owners could claim the costs of dealing with the cargo from charterers had not been addressed until the recent decision in the case of the Kos, and as we'll see in this case, along with the Astra, shows a general shift, arguably, in owners' favour. So, turning to the Kos, this concerned the withdrawal of a VLCC following a missed hire payment. Now, there's no question of damages arising in this case. It was one missed hire payment, and the parties had agreed at the outset that the non-payment did not amount to a repudiatory breach. The vessel was detained at the load port for just under 3 days while owners and charterers negotiated what to do with the cargo and how to discharge it and who was going to pay for it. The dispute then arose as to whether owners could claim from charterers the lost time and bunkers for those 3 days of detention. The expenses, in fact, were paid by charterers, so those didn't form part of the claim. Owners based their claim on two limbs. Firstly, bailment, which you'll be pleased to know I'm not going to go into now, and secondly, the employment clause, which in this case was clause 13 of the Shell Time 3 form, which provided an indemnity as well against all consequences arising from charterers' orders. And in this case, that included charterers' orders to load the cargo. Having failed in the Court of Appeal, the matter arrived in the Supreme Court, where owners' claims succeeded on both points. Now, perhaps of most interest to owners will be the use of the employment indemnity argument, which was used in a novel way, and arguably, and I'm not going to go into this today, it's for another day really, it arguably widens the scope of charter party indemnities, which are found in most standard forms, or alternatively are implied into most forms, for example, under Clause 8 of the NIPE. In this case, it allowed owners to claim, firstly, the time lost after withdrawal up until discharge, and that's claimable at the market rate. And secondly, it allowed owners to claim the costs incurred in relation to discharge after withdrawal. Now, following the costs, we see an improvement in the remedies available to owners. But has the decision in the costs already been overtaken by the more recent judgment in the Astra? For the reasons below, it arguably has, with the ground moving arguably, and I'll stress the word arguably, even further in owners' direction. The facts in the Astra are quite typical. It's a 2008 charter party, chartered at a rate of $28,000 per day for 5 years. Charterers, unsurprisingly, found it increasingly difficult to meet their payment obligations. In a falling market in 2009, 2010, they started to struggle to pay hire, and they sought a reduction in the hire due to owners. They threatened on more than one occasion to go into bankruptcy, and then they failed to pay hire in July 2010, when they also failed to pay a compromise agreement. The vessel was subsequently withdrawn by owners, and in this case, owners did seek damages, claiming that charterers were in repudiatory breach. The arbitrators awarded damages for lost earnings as a result of the charterer's repudiatory breach. However, the arbitrators based this breach on the charterer's wider conduct, so it wasn't just the missed hire payment, it was also for threatening to go into bankruptcy and failure to pay the compromise agreement. On appeal by the charterers, the High Court upheld the award, so agreed with the arbitrator. However, although it wasn't necessary, the judge in this case, who I think was also the judge in the Union Pioneer, Julian Flo, who's a rather revisionist judge perhaps, he looked at Clause 5, which is the payment and withdrawal clause, and he decided that that was a condition. Now, the important point here is that any breach of a condition amounts to a repudiation of the charter party and in turn entitles owners to claim damages for the loss of those future earnings for the balance of the charter. In short, therefore, the judge overturned the previously widely held view that a single breach of Clause 5 is not automatically repudiatory and does not automatically entitle owners to claim damages. So in practical terms, what does that mean? Treating the hire payment clause, that's Clause 5 in this case, as a condition permits owners to claim damages for just one hire payment that is missed by charterers. That's in addition, of course, to the right to withdraw. This ought to strengthen owners' position in all market conditions. For example, in a falling market, the threat of withdrawal rarely assists owners. but the added threat of a potentially substantial damages claim should persuade charterers to toe the line. In a rising market, a damages claim may seem less significant. However, the right to withdraw remains a powerful incentive to charterers to pay hire on time. And in addition, the damages claim can still assist the owners where the vessel is carrying cargo at the time of withdrawal. Now, the point hasn't been tested, and this is perhaps speculation on my behalf, but arguably the Astra may also provide an alternative route to the costs to enable owners to claim any and all losses incurred in carrying and, importantly, discharging the cargo following charterer's breach and the withdrawal. Right, conclusion. On the face of it, recent developments have seen a considerable strengthening of owners' hand in the face of non-payment of hire by charterers. The risks to charterers of missing just one hire payment for whatever reason are significant in all markets. And where the vessel is laden, owners can withdraw the vessel and claim damages for expenses and also for those lost earnings for the balance of the charter period. However, I would add two very important caveats. Firstly, even if a remedy in damages exists, that remedy is going to have extremely little value if the reason for the default by charterers is that they're going out of business, which unfortunately has been the case rather too often recently. Secondly, the decision in the Astra was obiter. In other words, it doesn't necessarily have to be followed by fellow judges in the High Court. While the arbitrators in London may follow the judgment, and Clive may have a view on whether he or his colleagues might do so, there's no guarantee at all that judges in the High Court will agree with Mr. Julian Flo in the Astra and uphold his decision, particularly as, frankly, it contradicts what had been the accepted position in English law for around 40 years. Accordingly, I'd suggest that owners are taking a risk if they withdraw after just one missed hire instalment. If they do so, and in the expectation that damages will automatically follow and future earnings can be recovered. In practice, therefore, until the law is settled, and that may take some considerable time before another case comes before the High Court and indeed the appeal courts, most owners may think that the most prudent course of action remains to wait and see. So, in answer to my question, is it time to rewrite the textbooks? Well, almost certainly yes. Wilford in particular will no doubt have a lot to say on this. But will it have such a dramatic effect in practice? I think that remains to be seen, and I suspect less impact than initially envisaged. Thank you very much.
Thank you very much, Jimmy, for your deep and